stand today, what is the difference? What is the dividing line between things a patent agent can do and a patent attorney can do?
All right. I don't know, Britt, if you, well, I'll run with that, and then, Britt, if you want to add anything, go for it. I mean, I think the clearest dividing line is just really honestly because the Federal Circuit emphasized it, and it's written out clearly. It's 37 CFR 11.5B1. That's really your, I mean, that's your, I guess, safe harbor, the clearest way of determining, okay, this is something a patent agent can do and expect to retain privilege. And there's just a list of things in here, which I talked about before, and is right on page 1301, also this In re Queen's decision. It's block quoted. So this really appears to be the clearest guideline for what a patent agent can do and expect to retain privilege, if I understood the question correctly. And Britt, I don't know if you have any sort of follow-up comment on that.
I think I would just emphasize the point that the scope of the privilege is delineated exactly by 11.5B1. That's it, right? Whatever the patent agent is authorized to do in that provision, or acts that are reasonably necessary to carry out those actions, that is all the patent agent privilege would extend to under current law. And as we've been mentioning over and over again, the boundaries of that are uncertain. And as Lloyd mentioned earlier, whether or not the privilege applies at all is the practice of law and is outside the scope of the ability of a patent agent to make that determination.